Hello, everyone. Thank you for joining us. My name is Dr. Deborah Rose with Health Management Associates. I'm thrilled to also be joined by my colleague, Rachel Johnson-Yates, and together we'll talk to you about the CARE Act eligibility. So why don't we get started? A little bit about us. Rachel, also from Health Management Associates, is a licensed mental health and addictions counselor. She's a public speaker and she's an educator. And she's created and developed and helped expand many programs in behavioral health, carceral settings, substance use. She's really dedicated her career to working with folks who have to incorporate equity principles and through a trauma-informed lens. And as I mentioned, she's been part of these settings and have had leadership roles in many of them. I'm a New York licensed psychologist. I got my start a number of years ago in outpatient commitment laws with Kendra's Act in New York State. I've had roles in both not-for-profit social service settings as well as carceral settings. So today we come together and I hope that you can walk away with a little bit more information from what we're going to share about eligibility for the CARE Act. Little bit about what we'll talk about. We'll go over the eligibility criteria, including the diagnosis. We're going to give a case example that we will use throughout the training, a fictionalized example of somebody that might be similar to people that you work with. And then we'll talk about various points or key points where eligibility is determined throughout the CARE process. So hopefully by the end of today's training, you'll be able to describe the CARE eligibility criteria, as well as the diagnostic criteria, but some of those others that are important to meet CARE eligibility as well. And then you'll also be able to identify some of the key points or moments where eligibility is considered throughout the CARE Act process. So with that, I think we're going to jump into the content. And Rachel, I'm going to turn it over to you.
Thank you, Deborah. Go ahead and go to the next slide, please. So here, as we get started, we want to share with you this workflow that helps outline just kind of an overview of the CARE process and at what points eligibility will be defined. So as you click through this slide, you're going to start to see some red squares show up that indicate all of the places where we will be evaluating whether or not an individual that is involved in the CARE process initially meets eligibility criteria and or is continuing to meet eligibility criteria throughout the process. So again, as you're taking a look at this diagram, you can see the little red rectangles pop up that say meet criteria, and these are all the points where we're going to be zooming in a little bit today. So if you don't mind going to the next slide. So to get us started, we want to take a look at a case example. It's really important to remember that first and foremost, within the CARE process, we are here to serve real people. And so we have done our best to come up with a case example that's representative of some of the people that are being served during the CARE process. And so we've come up with a case example that's hypothetical of our individual named Ming. Ming is 42 years old. She's single, and she's enrolled in an outpatient behavioral health clinic where she's been diagnosed with schizophrenia. She is a very creative person who enjoys painting and the arts, and that's a really wonderful primary outlet for her. She's currently living in a board and care home and recently has stopped taking her antipsychotic medications, which has caused a spike in acuity of some of her symptoms of psychosis and having some struggles with delusional thinking, etc. She was recently brought into the emergency department, but ended up being released because she was not an imminent threat or gravely disabled. However, her symptoms are still at a really high level and a level that are starting to disrupt her functioning. We've been seeing that Ming is becoming progressively more paranoid, in particular regarding her caregivers. She's having a lot of paranoid thoughts about whether or not they may be trying to harm her or control her. And these sorts of thoughts that she's having is really starting to negatively impact her relationship and her functioning inside and outside of her household. The caregivers are feeling very concerned about Ming's well-being and feeling like she's not really able to be stabilized right now in the outpatient behavioral health care services that she's getting, and think that maybe care could be an option for her. So as we're going through the content today, the main question that we're going to be navigating is whether or not Ming is eligible for care. She may be eligible because of her diagnosis, but as we'll talk about more and more throughout the content today, diagnosis alone is not enough to be eligible for care. So we need to dig a little deeper into Ming's situation to see how she's doing, what's going on, and whether or not she meets eligibility criteria. Okay, so when we talk about care eligibility, here we have a standard list of all of the things that go into whether or not a person is eligible. And we will be breaking these down bit by bit in today's presentation so that hopefully as you leave the presentation, you'll feel really confident and comfortable in navigating eligibility for care. So to be eligible for care, a person has to meet all of the following requirements. They have to be 18 or older. They have to be experiencing a serious mental disorder and have a diagnosis of schizophrenia spectrum or other psychotic disorders. Their symptoms have to be severe and persistent and to a level that they're interfering with the person's daily functioning. They need to be in a state where they are not stabilized, even if they are participating in ongoing voluntary treatment. We have to understand and believe that care participation is the least restrictive alternative for this individual, and that they will likely be able to benefit from participating in either a care plan or a care agreement. In addition to all of these things, at least one of the following have to be met as well. We have to have a reasonable understanding, a clinical determination that a person's unlikely to survive safely in the community without supervision, and that their condition is substantially deteriorating at the point of petition. And we also have to believe, another option of one of these two is that we have to believe that intervention is needed to prevent relapse or deterioration. And so again, all of the following in the top section have to be present, and at least one of the following of the bottom two have to be present. All right, so let's dig in. Our first question is whether Ming has an eligible diagnosis for care. And so within the realm of diagnosis, a person has to have a schizophrenia spectrum disorder or another psychotic disorder in the same class as defined by the DSM. We can include historical or provisional diagnoses. And if there's co-occurring substance use disorder that may be occurring, it's important to indicate that. However, that would not necessarily exclude the person from being eligible for care. We'll talk more about that in a moment. Next slide, please. So when we're talking about schizophrenia spectrum and other disorders, it's important to know that this category includes multiple other diagnoses in addition to schizophrenia and schizoaffective disorders. The common feature that we're looking at is psychosis, and there are many of these conditions that are included in the diagnostic eligibility list for the CARE Act. And so you can see on this illustration to the right, the list of diagnoses that may be considered in the care realm. And let's break down what is eligible, what might be eligible, and what is not eligible for care. And so you can see around kind of the top half, the ones without any highlighting, are all diagnoses that tend to be indicated to support eligibility for care. So we see things like schizoaffective disorder, of course, schizophrenia, schizotypal personality disorder, delusional disorder, and others that are typically indicative of eligibility for care. Down to the bottom left, we see some diagnoses that are highlighted in blue, including schizophreniform, substance or medication-induced psychotic disorder, or brief psychotic disorder. These are diagnoses that may be eligible for care as long as they are meeting the recommendation or the requirements around being severe and persistent. And so these diagnoses alone need a little bit more digging to see whether or not they meet care eligibility. The diagnoses highlighted in red, the psychotic disorder due to a general medical condition or catatonia associated with another medical condition, do not meet care eligibility unless there's another accompanying eligible diagnosis that is present for that person. And so keep this list of diagnoses handy. This is a really great quick reference list to say, first step in eligibility, how are we doing in terms of diagnosis? Do we have a diagnosis that might be in the running for being able to refer somebody to care and have them be eligible. All right, next slide, please. So what is important to know about diagnosis is that diagnosis alone is not enough to be eligible for care. So in Ming's situation, we're seeing that Ming's symptoms of paranoia and auditory hallucinations, we are seeing that they are severe because they are interrupting her daily activities. They are persistent, so they've been going on for quite some time at a pretty high level. We're seeing that her symptoms interfere with her primary activities of daily living, and causing issues like being hospitalized, disruptions to her primary relationships and other things. Ming is currently engaged in outpatient behavioral health services, but despite those efforts, has not been able to be stabilized through those services. We are seeing that care is likely the least restrictive alternative for her, meaning that a higher level of care may not be necessary to get her stabilized. Lower level of care we're seeing is not enough at this point to get her stabilized, but higher level of care may be too much, where the care act process might be right in that sweet spot of what can help her get back on her feet, achieve stability, and be in a better position to be functioning, meeting her activities of daily living, etc. We're thinking that Ming will likely be able to benefit from participation in care due to her historic ability to stabilize with slightly higher level of support. And we're seeing that she's unlikely to survive safely or independently, and that her condition is deteriorating as we're going through the process of evaluating her eligibility. So we're seeing this kind of spike in intensity. We're seeing that she's getting hospitalized. We're seeing that her symptoms are getting worse. And we are evaluating that it is likely that services and supports are needed to help prevent further deterioration for Ming. Next slide, please. Okay, so when we think about whether or not she's experiencing a serious mental disorder, we have to meet, as we've talked about, this criteria of the disorder being severe and persistent, interfering with daily living, and having an impact on stability or functioning. So we've talked about with Ming, just to highlight this again, we have seen that all three of these categories of eligibility are being met in her example. Next slide, please. Clinical stability. So we want to know, as we're referring her and evaluating her eligibility for care, whether or not she's clinically stabilized. So what we're seeing is that right now she is not at a level of being clinically stable. She's participating in outpatient services, but she's not fully engaged. And that is evidenced by her discontinuation of her mental health medication and the spike in acuity of symptoms that occurred after that discontinuation. And so you may see with other folks some other evidence of not being stabilized. So engagement may vary. It may be that the person's declining services, and that may be consistent or intermittent. Or we're just seeing that person is participating in treatment. However, it's not seeming to meet the need of the individual, and they aren't able to get stabilized and resume healthy functioning despite the efforts of the outpatient engagement. In terms of trying to define clinically stable, we look at a number of factors. First, we're looking at whether or not the person is managing their symptoms. For many mental health conditions, it is not an all or nothing sort of situation in terms of symptomology. A person is not going to have an on or off switch. It's really about, are their symptoms manageable? So as an example, if they're having some auditory hallucinations, are they able to understand that they are hallucinations and cope with them and still function through the symptoms that they're having? Are the symptoms at a level of intensity, severity, frequency that the person is generally able to function well in society despite the presence of the symptoms? We're looking at behavioral stability. So are there instances happening with them where maybe they're engaging with emergency departments or law enforcement, or having conflict with loved ones? We're also looking at whether or not they're able to engage in therapeutic interventions. So what is their participation looking like? Is their symptom acuity so significant that when they are attempting to participate in individual or group therapy, as an example, that they are not able to function in that sort of environment, and they're not getting a benefit out of the the treatment setting due to the severity of symptoms they're experiencing. We're looking at their day-to-day functioning, as we mentioned, and we're trying to look at the risk of harm to self or others. And this may be an active ideation of feeling suicidal, feeling homicidal, having plan, intent, means to hurt themselves or somebody else. It can also mean that that person's behavior has become so erratic that there's a risk of them accidentally hurting themselves or others. And then also, are they able to make progress toward their recovery goals, or are they feeling really stagnant and or deteriorating to a point that we're feeling concerned? And if that deterioration is present, that's another supporting factor for that person potentially being eligible for care. Next slide, please. When we're talking about the deteriorating condition, we want to ask, is Ming's condition deteriorating? And so when we're looking at this, we want to evaluate whether they're unlikely to survive safely in the community without supervision or intervention. And this usually is an indication that the person's condition is progressively deteriorating. So we're seeing an uptick in things like arrests, hospitalizations, emergency department, crisis interaction, those sorts of things. Whereas maybe they were stable and only accessing these sorts of services intermittently, we're starting to see them happen more and more and more. And the reasons maybe that these interactions are occurring are becoming more significant. Or we might see that services and supports might prevent a relapse or deterioration that could lead them to a grave disability or harm to self or others. So this might be where we are starting to see the deterioration start, and we want to intervene prior to this person deteriorating to a point that their functioning is really significantly limited, putting themselves or others at danger. In terms of additional requirements, we want to make sure that care is the least restrictive alternative. So here, we want to make sure that participating in a care agreement or plan is the least restrictive alternative for that individual. So again, if we think this person actually might be able to, they're not engaged in any sort of outpatient treatment, they have stabilized with standard outpatient treatment before, let's see if we can get them stabilized in that manner. That is perhaps the least restrictive alternative for them. In Ming's case, we are seeing that she has been participating in outpatient treatment, and it has not at this point been enough to keep her stabilized. So we want to make sure that we are doing the best we can to honor that each person's freedoms and preferences and engagement and preferences as well. And we also want to look to make sure that the person's likely to benefit from care. And what we know about the care process is that it really helps connect services that have a holistic approach to serving the individual. And so as a person's participating in care, they can benefit from a really holistic and all-encompassing care agreement or care plan that includes things like medication, care coordination. It may connect them with wraparound services like full service partnerships or FSP, ACT services. And we also want to consider how the care process may improve or enhance the care of the individual or promote their recovery. Next slide, please. So as we're thinking about eligibility, there are a lot of factors that may feel confusing for people as they're first getting their feet on the ground in terms of the care process. And here are a few myths that are really important to call out as folks are really digging into what does eligibility mean for care. The first myth is that there has to be evidence of 250/250s, and that is required for care eligibility. The fact is that declaration, evidence, or other documentation of at least 250/250 intensive treatments, one of which is within the previous 60 days, is just one possible option to support a petition form, but is not required to support eligibility for an individual. And so as you're thinking about this, 5250s can always be used to help enhance rationale for eligibility, but they are not required. So if you have that information, you're able to include it in the petitioning process, that's great. But again, not required. Another myth that we hear a lot is that someone enrolled in outpatient treatment already is not eligible for care. The fact is that anyone who is participating in ongoing voluntary treatment may still be eligible for care if they're not clinically stabilized and they meet all of the other eligibility requirements. So if you have somebody that is in outpatient treatment, but really, really struggling to stabilize, maybe seeing some really significant symptoms of deterioration, they may very well be eligible for the care process. Another myth that we see is that substance use automatically disqualifies someone for care. So a substance use disorder is not a standalone diagnosis when considering eligibility. However, it absolutely can be co-occurring with an eligible diagnosis of schizophrenia spectrum or other psychotic disorders. We see a lot of the time individuals that have qualifying and eligible diagnoses that have a co-occurring substance use disorder. And in fact, some substance use related diagnoses like substance or medication induced psychotic disorder are eligible diagnoses as long as that severe and persistent criteria has also been met. And so that's the really important factor to note is it has to be an eligible diagnosis, and to be eligible, this differentiating factor of severe and persistent is really, really important. Next slide, please. Okay, so Deborah, I have a couple, I'd love to talk to you about this a little bit. So we've been thinking about Ming, and we're really wanting to know, do we think that Ming, with the information that we have, meets criteria? So I don't know, with everything that we've discussed so far, what are your thoughts on Ming and whether or not she may be eligible?
Yeah, great questions, Rachel. Thank you. And thank you for everything that you've shared so far. When asked about if Ming meets criteria, we could take a look at some of the bullets that are on the screen and go through them. Is her diagnosis a qualifying diagnosis? Well, we know that Ming was diagnosed about 18 years old with schizophrenia. She may have some substance abuse. That's okay. As Rachel said, there can be a co-occurring substance abuse, but what really matters is that there's also a diagnosis of schizophrenia or another psychotic spectrum disorder. And so in diagnostically, yes, Ming meets criteria, that eligibility diagnosis criteria. Symptoms are severe and persistent. She's been symptomatic for about the past 10 years, particularly when she goes off her meds. We see her having some increasing paranoia and some distrust to the people that she's working with in the board and care center. Is she unlikely or is she likely to be at risk? Or is she not surviving safely in the community? Well, yes, because of that paranoia and the distrust of her care partners, she has been leaving the board and care residence. She's wandering the street at night. That is absolutely placing her at risk. Is her condition deteriorating? As we just talked about, she's becoming increasingly paranoid. She's not taking care of her personal hygiene as well as she was. She's found talking to herself more frequently. The symptoms are more intense. She might not be able to recognize that these are symptoms that she can live with. And so her condition is absolutely deteriorating, and it's seen on a daily basis. And then certainly care would be a less restrictive alternative than some of the others, including hospitalization or conservatorship. So when we're asked, does Ming meet or appears to meet criteria, it does seem that there's enough to at least complete a petition and to present the information to the court for their assistance and for their determination of Ming meeting care criteria.
That's great, Deborah. Thank you so much. And we'll continue to talk about this throughout the presentation, but it is really important that folks listening to this training do remember that if you are not sure that a person is eligible, but you think that they might benefit from participating in the care process, please go ahead and submit that petition. You don't have to have foolproof, airtight evidence of eligibility. That's part of the realm that the courts and behavioral health work on together to determine eligibility. So it's great if you have this information, but if you don't have it all, that's okay. But yeah, thank you. I think I agree with you, Deborah, exactly what you described. That's kind of how I was conceptualizing her case and thinking about that, as that petition was submitted, that the court and the behavioral health team would have an opportunity to dig in a little deeper and really kind of finalize whether or not she's eligible.
Indeed.
All right, come kicking it back over to you.
And don't go far because I'm going to bring you back when I'm done, Rachel.
Right here.
So let's move into some of the process. Rachel did a really terrific job of helping us understand who might be eligible for care. Let's talk about how that's applied with the CARE Act process. And you see here a very colorful diagram on your screen. The left is the referral and petition process, followed by the engagement. Towards the middle, we have the court process, and then ongoing services and ongoing involvement. So I'm not going to get into each of these today, or I'm sorry, I'm not going to get into each stage of this today, but I am going to focus on a couple of key points. We're going to talk about the petition. I'll talk about the county report, and if there is a reappointment at the end of a year, I'll talk about what eligibility might look like there. And I'm going to get into each of those in details as we move forward. Let's go to the next slide. Oh, we're there. Perfect. Thank you. So starting with the left side of your screen, we're going to look at the petition. Again, these are required elements for the submission of a CARE petition. The petition is the first place where eligibility might be considered. We'll then go into the county report in a whole lot more detail, and then the clinical evaluation, which is used later on potentially for a care plan, how the court may consider those things for eligibility determination as well. Beginning with the petition, and I'm mentioning it a couple times because we do think that it's so important that you understand the difference in how each of these are used at various times. So beginning with the petition, this is again those statewide forms that are required for a petitioner. It could be the county behavioral health agency. It could be a petitioner in the community, like a system partner, a family member, perhaps a treating provider. But it's the petitioner who's completing all of that information. And information that goes into these forms are used to support, or at least to enhance the idea that the individual meets or may meet eligibility criteria. Really important that we note the language is meets or may meet, because as Rachel said, you don't have to prove. It's with good faith and your best belief that you think the person meets criteria. It's really up to the court to determine if that's been evidenced. At this point, you're putting in what you believe will show. You write what you know. You don't have to prove it. And so that information goes into the petition. And the information is again used by the court to create what's called a prima facie review at first glance. That's where the court decides this person appears to meet criteria. Again, that meet or may meet criteria. And depending on who the petitioner was, there might be a request for a county report. Moving over to the county report, again, following prima facie, the court has said, yes, this person appears at first glance to meet eligibility criteria. The court, if it is an outside petitioner, if it's a community partner, or let's say a hospital, a treating provider, a family member, if it's somebody other than the county behavioral health department, the court will order the county to do an investigation and to submit a report to the county, to the county court, to the judge, to the court. And so this investigation will include a couple of elements. It'll include a behavioral health assessment, brief one. This is not a full evaluation. It'll include details of the efforts to engage somebody, what kind of outreach has been done, how did the person respond to those outreach and engagement efforts. That'll be documented along with what some of those outcomes were. And so again, if it is an outside petitioner, the court will order this report, which will be done, and it will be used to set an initial hearing date, which may be combined with hearing on the merits. And I'm going to talk about that in a moment. So if, let's say, Ming's family member or provider in her outpatient clinic filed a petition, the court would then say to the county, we'd like to learn more about Ming. Please go out and meet with her, do an evaluation, let us know how that went, and give us your impression if she appears to meet criteria. If, however, the petition was filed by the county, they're completing it They have the information. It's somebody who's known to them and they believe the person might benefit from care. If the county completes the petition, the court might not ask for a report. It's not a requirement. The court would, if they're looking for more information to support the petition, could ask for a report, but it's not a required element of the statute. In either case, the information is then used to go to a hearing on the merits, which again may be combined with with the initial appearance. I'm going to fast forward a moment, and here we have already passed these things. We've gone to a case management hearing, and we will be able to show it to you again on the diagram in a moment. At this point, there's a third place where eligibility might be assessed and shared with the court. If the individual is really on board, if we don't think that an agreement is likely to happen, if people aren't seeing eye to eye on what might go into a care services, then there may be a case management hearing where the court will order a clinical evaluation. And so this clinical evaluation has a few additional components similar to the county report. This is done by a licensed behavioral health professional who's working with the county behavioral health department. And the absolute required elements would include diagnosis, again, looking for that schizophrenia or psychotic spectrums, capacity to give informed consent for medication, and also looking at whatever other relevant information is available, including recommended supports. What might the person benefit from? And all of this is done using a standard of clear and convincing evidence to help the court make a determination that the individual meets or may meet eligibility criteria. So if we go back to Ming for a moment, let's say she wasn't fully on board, she didn't want to be part of a care agreement, the court might say, okay, county, let's go, please do an evaluation, and then together we can create this package of services, and they would order this evaluation to occur through the county. I think we can go to the next slide and look at all of these now in depth. We've talked about who might complete them and why they're used. So I'm going to, again, these 3 touch points, I'm going to break them out a little bit more. So again, the first stage is the petition. This is where the petitioner, whoever is submitting the petition and the required elements, will file with the court and will provide information that helps them determine if the person meets or may meet criteria. We've talked about some of that eligibility before. Certainly diagnosis, is something as severe and persistent? Does the person seem to benefit from services? Is the person non-engaged or not responding to voluntary outpatient treatment? So all of that goes into a petition. And I'm going to reinforce again that the petitioner, while they're making essentially an attestation that they believe the person is eligible for care, they don't need to know for certain an exact diagnosis. They don't have to have all of the information, even all of the history or current services. Really should be documenting what they know, what their beliefs are about why the person meets the criteria, and enough to give the court the impression to make that determination. So if we go back to Ming, let's say perhaps it was a first responder, somebody who is seeing Ming on the streets in the evenings and is interacting with her regularly. That first responder might not know a diagnosis or if she's in treatment or not, but they could be writing, they see somebody talking to themselves, they see somebody wandering, perhaps wearing the wrong clothing for the weather, somebody who seems disheveled and appears fearful. All of that information, again, put down what you know, is helpful for the court to make that determination. Couple things that I think are really interesting here is that often there are various people who could complete the petition. And so the goal is whenever possible to work together. Perhaps it's a family member and a physician who's partnering, or a family member who's contacting the county behavioral health agency, providing them with information. So that together, those eligibility criteria, which may come from multiple people who are involved in the individual's care or the absence of care, care with a little c, combined with those other required elements, the declaration or evidence that bolsters the petition, can be used to provide the court with information. We've talked about the petition a bit. Let's go forward to the next slide. And here we will see the prima facie determination. Again, prima facie means first glance. Latin, prima facie, first glance. And so essentially what that means is there enough for the court to say, yeah, that seems like this may be the right fit. This person may or meets eligibility for care services. If the court has enough information and they determine that the person does meet the criteria based on prima facie, then again, if it's an outside petitioner, outside other than the county behavioral health, the court will say to the county behavioral health, please do an investigation and file a report. If the court has determined that the person appears to meet criteria and it was the county behavioral health agency, again, they could ask for more information. They could order a report. They don't have to do that. The idea is to give them enough information that supports the petition and the next stage. What happens, though, if the court determines that the person does not meet criteria? Perhaps they don't have a qualifying diagnosis, or perhaps it is evident that the person is in another state, or perhaps is really engaged in care. The court can dismiss the petition. And what's important to remember here is that even if a petition is dismissed, it's essential that the county and the petitioner and others who are involved with this individual really work together and try to connect a person to support services, things that are available in their community, so that there could be a warm handoff and that supportive intervention, supportive assistance can be provided. I've mentioned the county report a number of times, so let's talk about this some more. And I'm certainly repeating myself a little bit, but we think it's pretty important that you understand this. We're all still learning as we go. So again, the county report here, if the behavioral health agency is not the petitioner, let's say it's a first responder or a family member or a hospital provider, the court will order an investigation. That investigation and the report that follows will help the court determine if the person meets eligibility, if they meet or may meet eligibility. It'll also help them understand what kind of outreach and engagement efforts have been made and if the person has responded to those efforts. And then last, it'll include conclusions, recommendations, other things that the county wants to share with the court. Once again, if the court is working with the county who filed the petition, if the court wants more information, they may order the county to provide additional information, and that will result in a county report or supplemental information going to the court. Let's go to the next slide, please. So here, and you could see somewhere around the left side of your screen, under the rectangles that says meet criteria, we have the prima facie hearing. And again, what might happen is one of three things. The court could dismiss the case here. Let's say that Ming has said, that's great, sign me up. I want these services. I'm on board. Thank you for helping me. And she agrees to this voluntarily. The court could dismiss this, and we are noting that voluntary engagement was provided and has been effective. And that's why those the outcomes of outreach and engagement are asked as part of this report. If the county court determines that the report does not substantiate or does not demonstrate eligibility enough for a prima facie showing, then the court could dismiss the care petition. And then last, if the individual has not agreed to a voluntary enrollment, and it does appear that the person meets criteria, then the court will set an initial appearance. Again, that could be combined with the hearing on the merits. At that point, the court will appoint counsel for the respondent, which is available to everyone who is involved in a care petition or a care process. And they will order the county to provide notice of the initial appearance and hearing on the merits to the petitioner, to the respondent, to the appointed counsel, to the county behavioral health agency where the person resides, or perhaps to the county where the court proceedings are occurring. Perhaps somebody is in a hospital in one county, resides in another county, so we might see some overlap there. So again, notice informing folks of the initial appearance and potentially the hearing of merits. Let's keep going. As we talk about the initial appearance and the hearing on the merits, it's important that the petitioner be present. Statute says shall or may be present. Court could dismiss a case if the initial petitioner is not present. We are hearing that they're generally short, and most of the counties we're hearing are setting up remote appearances to try to simplify the process. And so that can happen. Certainly the individual can appear, or through their counsel, Ming could say to her appointed counsel, I don't want to appear, and she doesn't have to, but certainly the behavioral health agency, the respondent, if he or she chooses to do so, and then the attorney. We talk about the hearing on the merits. So the court will determine by clear and convincing evidence. This is where we use that term again, clear and convincing, that the respondent meets eligibility criteria. And this is where the court will look at the report and the other additional information to support the petition and moving forward towards a care agreement or a care plan. Next slide, please. Clinical evaluation. At this point, the individual has declined to participate, so it seems like coming to a mutual agreement is unlikely. The court will order a clinical evaluation through the behavioral health county agency. Will happen in a number of cases, certainly if there was no existing clinical evaluation, or if the most recent one was outside of the last 30-day period, and if the parties don't stipulate to a clinical eval that's been in the last month. So the court says to the county, please meet with the person, do a more detailed evaluation to help us determine the next possible steps. Evaluation will be done by a licensed behavioral health person. This is somebody who is working with the county behavioral health agency. And certainly the evaluation needs to include a clinical diagnosis. It needs to include an assessment of one's capacity to give informed consent for medication, specifically for the psychotropic medication that may be ordered. Any other relevant information, we might want to look at somebody's hospitalization history of legal involvement, or other outpatient commitment involvement. And then it should include a recommendation of services, medication, housing, programs, FSP, ACT, or whatever else might be a reasonable package to help the individual and to support recovery in the community. Let's go forward then. So the evaluation has been done. We're now on that lower shape on towards the right of the screen. The evaluation has been done, and there is now the hearing based on the clinical evaluation. It's called a clinical evaluation review hearing. This is where the county behavioral health and the respondent can be present. They can call witnesses, including the licensed behavioral health professional who did the evaluation. And this is where the county will look and to help make a determination, or will make a determination if the person meets care eligibility. So at the end of that hearing, one of two things might happen. One is that the court finds that the respondent meets criteria. They've looked at the eval, they've looked at all other evidence. They say, yes, this person meets the care eligibility criteria, and they will set a care plan review hearing that will happen within the next 14 days. And that's the time where they start to look at a care plan. What are the kind of services that will be written in to support the individual? So in this case, maybe Ming, her appointed counsel, are coming back and saying, looking at medication, other kinds of treatment options, peer services, whatever is needed or is preferred by Ming and those who support her to create a care plan. If, however, again, at this juncture of the care management hearing, they find that the respondent does not meet the criteria, then the court could dismiss services. and dismiss the petition. And so again, we would hope that the county and others will rally together to provide whatever other services are needed in the community so that we can support individuals outside of care. And then we will go ahead one more. I'm going to skip over a number of the steps that will happen over the next year, potentially two. But we know that the care is a 1-year process. If the recommendation is made that that process is renewed, which can happen after 1 year, one time, so potentially care can be renewed so that there's a total of 2 years. At that review, the 1-year review hearing, again, eligibility should be examined because the person still needs to meet care eligibility in order for there to be a renewal of an additional year. So that same eligibility that we've talked about, diagnosis, functioning, less restrictive option, all of those things that we've talked about a lot today would be included in the material that's going to the court to request an additional year of services. So we've said a lot, and I'm going to pause and I'm going to ask Rachel to come back. And I will ask you at this point, Rachel, as we start to sum this up, what kinds of questions do you think, or what additional questions would you have about the role of eligibility? And then with that, since we've talked about a lot of people who are involved in eligibility assessments and reports, is it clear what roles different people would be playing here?
No, thanks, Deborah. You know what, I think as you're talking through the first question about additional questions that might be out there about the role of eligibility, what comes to mind for me is, you know, throughout all of these different points, and especially at the prima facie um, uh, point in the care process, there's a lot of factors that go into determining eligibility, right? And so what are your thoughts in terms of final responsibility for whether or not a person is eligible? Because there may be many people that are involved, right, that have different opinions. So where does that land?
So I think it's a great question, and thanks for punting that back. We think about really, will the person benefit from this? This is the most important part. Is this a service and a support that makes sense to the person? So I begin with that. How can care help the individual? I also think that, ultimately there are very well-intended people, family, providers, others who want what they believe to be in the best interest of a respondent, and maybe filing a petition. Ultimately, it's up to the court, and we need to recognize that. So with a best effort in mind, putting together that information, again, there's the client, the respondent. That's one key person. And we're hearing that there are individuals who are petitioning the court with the help of a lawyer for themselves. They want access to some of the services. They want the additional supports that could be provided through care. We think about the petitioner, right? Again, I've mentioned a number. It could be the county BH. It could be a family member, a roommate, somebody who is in a community provider setting, another stakeholder. Really important that they include the facts that, again, allow the court to make that determination. They need to feel comfortable with it. They need to provide enough information that supports the ask. But ultimately, it really is the judge who will take the petitioner's information and make the determination. Certainly the county, they as petitioner and as support should have enough information based on the individual's presentation and history to allow the court to make a determination. And then last, the judicial officer. You asked who do I think is really important here? Ultimately, it is the judicial officer. It is the judge. And so our jobs as providers and as supports are to lend enough information to that person, to the judge to make the final determination.
No, thank you. I think that's really helpful because I know in our work in the care realm, we've heard stories of initial petitioners feeling, that maybe friends or family or the individual themselves that are feeling a lot of pressure to get it perfect in terms of the eligibility evidence that they're submitting. And sometimes there's going to be information that is missing if I'm a family member that is trying to get my loved one some help. And knowing that pressure is alleviated a little bit, that we can do the best we can as petitioners to help support eligibility. And then there's a process in place, as you really well described, to help fill in any gaps that might be present. And then ultimately, that there's this responsible party of the judicial officer who's kind of taking all of this information in consideration and really trying to make a well-informed decision in terms of what is going to be in the best interest of the person being served, and you know, and within that, trying to respect that person's rights and their preferences, and be trauma informed in the way that this is operating. I think all of that is really important when we focus on the fact that, you know, this entire system and process is designed to help individuals who may really benefit from all of the potential services wrapping around and supporting them until they can start feeling a little bit more stable. So thank you, Deborah, very much.
Thank you, Rachel. So let's go quickly. I'm going to wrap this up, and I hope that you've heard Rachel and I talk a lot today. I hope that you have now more understanding of the eligibility criteria, how diagnosis is one of those factors, what the others look like, and then also how the eligibility is used at different points, the petition, the report, and the clinical evaluation. If you'd like more information, I would encourage you to go to the care-act.org website. There you can sign up for regular newsletters and information. You can be put in touch with people who live and breathe care and want to help continue education on this topic. And you can request specific education, technical support, or training. And so with that, I want to say thank you to the folks who have chosen to spend your time with us and listening to this webinar. And I appreciate your participation. Bye.